Welcome to another wonderful spring day in DC. Just looking at this picture makes me love being in the district. I know a lot of the cherry blossoms are already beginning to drop, but spring is sprung and we are here. So I welcome everybody for joining yet another webinar. Today, we're going to be talking about what it looks like to be staying in compliance in DC, because in the end of the day, you want to protect your property. You want to be mindful of your tenants and taking care of them. And of course, protecting your bottom line. My name's Conrad Bennett. I'm with EJF Rentals, and I've been working with property management and working with owners and doing property management for over 20 years, giving guidance as a property manager. And sometimes we need an attorney to be able to give a little extra direction. I've been real fortunate in working with Brian of Offutt Kerman for, dare I say it, nearly 9 years, and his predecessor well before him. But ultimately, occasionally bad tenants can be costly, and you got to do your due diligence and do the appropriate paperwork, and that goes a long way in a tenant-friendly jurisdiction. We're going to have a couple of opportunities to ask some questions at the tail end, but I hope you'll let us go through this, and you are more than welcome to put notes in the chat as we go. We'll revisit them when we get to the tail end of the presentation. And so today we're going to talk about why rental rules matter, what matters. We need to cross our T's, dot our I's. Obviously, we all want to hope for the best, but you got to plan for the worst. We'll expand upon what that potential impact for noncompliance looks like and what the Office of Administrative Hearings role is when you hit those challenges. We're also going to expand upon DC's licensing requirement. Even though we had a prior session about what it looks like to be able to get your license and what that housing inspection looks like, we're going to talk a little bit about what maintaining that license going forward. But we're going to, the new expectation with DHCD, the Department of Housing and Community Development, is about the new registration, the rent registration. We're going to expand upon that today as well. So I've got Brian on here, and one of the big things that we're always looking at is making sure that we are not only getting the license, but maintaining it. And there are certain language added into the disclosures and the leases and all of the other stuff that we need to make sure that you are remaining in compliance. Because if you go out and get the license, you got to make sure that people are aware of it. And so I've worked with owners that have gone out and got leases from other jurisdictions, and DC is essentially a beast of its own. And so now, with the market evolving and a lot of new expectations, there is a requirement that when you have that license and that rent control registration numbers, they're going to have to appear, and they're going to have to be shared. So, Brian, you mind expanding upon where these need to be referenced and what the front end aspect looks like as you begin to not only market, but process applications, draft leases for future
Yeah,
residents?
yeah, absolutely. Yeah, thanks, Conrad. Happy to talk about that. And thank you to Conrad and EJF for having me. It's good to be with you guys today. Conrad's absolutely right. So you talk about crossing your T's and dotting your I's. What we found coming out of COVID and a lot of the new requirements and statutes and even new district municipal regulations is that a lot of landlords were, partially compliant. They might have had issues with RAD forms that were filed years ago. I'm sure Conrad has seen those RAD forms from the 80s that are still out there floating around and attached to properties. And it was never that big of a deal. I mean, it was something that we always had to worry about and you always had to do. But now, as Conrad alluded to, it's very serious because there are administrative implications for not being compliant. There are civil implications, and you have an access to the court issue, right? So all of this sort of starts with the lease or with marketing, and really at the time of application. It's very far upstream these days. So what's important to remember, if you're pulling in a lease from another jurisdiction, you want to have somebody take a look at it. I know Conrad's got a fully compliant lease package. They're on the up and up, but you might have rented your property out before you search for a property manager or something like that. You're going to want to look to make sure that your lease is compliant with District of Columbia law specifically. Even a near Maryland jurisdiction lease is not going to work in the District of Columbia I think I saw one recently from Texas, and I didn't even scroll past the first page. I was like, this is not going to work. We're going to have to redo this. Um, so it's important to talk to somebody or have somebody at EJF take a look at your lease before you just haul off and start executing it. Same thing goes with the application, right? So the idea here is that when a tenant walks in to apply, or they give you a call, or they give EJF a call, you want to make sure that you're disclosing not only what the rent is, which seems obvious, and what the fees are, and which ones are non-refundable, and which ones are refundable, which ones are voluntary, which ones are mandatory. So things like utility payments versus do you want to have a parking spot? Anything like that has to be disclosed. But if you're going a step further and looking down the road, trying to mitigate risk on the back end, you're going to want to make sure that you're providing the DDL and the RAD information right up front, right? So one of the first changes, and I believe NAA, I think GCAR probably did the same thing post-COVID, was slapping the rent control registration or exemption number right on the front of the lease, or including those as attachments to the lease. I even recommend doing it at the application stage, right? Before a tenant signs a lease, they are being made aware that you are either subject to or exempt from rent control. Here's why that's important. There's bad case law out there for landlords who don't follow this, coming from the Office of Administrative Hearings. And what it basically says is that tenants have a right to know upfront whether they're moving into an exempt property or not. If they are, and you don't tell them that they are, then you've got the specter of a case years down the road potentially where they say, well, I moved into this property, but I had no idea it was subject to rent control. And as the theory goes, I would not have moved into this property had the landlord told me about that ahead of time. That causes a massive problem. Conrad referenced rent rollbacks and the role of the Office of Administrative Hearings. That's the kind of thing that gets litigated at the Office of Administrative Hearings. And if you can't prove that your disclosures were solid at the front end, you have real exposure on the back end, right? The court could rule that, notwithstanding the fact that you're a small landlord, or that you have a new build, or that the tenant was subsidized, or whatever the case may be, in terms of those exemptions you see on the RAD form, notwithstanding that fact, if you didn't tell them about it at the time of lease signing, either on the face of the lease in the application, the regulations actually say posting, which I think is probably the most difficult one to prove or disprove. So I think we generally stay away from that. But if you can't prove that that was done, the court can order a rent rollback subject to rent control. So they'll say for a period of 3 years, which is the statute of limitations going back, you have been subject to rent control, and any of the increases that you've taken since have to be rolled back to the level 3 years ago. You actually can go a little bit further back now. So the COVID tolling statute, if anyone remembers, during COVID, they told every statute of limitations. You can go back further than the ordinary statute of limitations, provided the claim is brought within a certain time frame. I won't reference the dates off the top of my head because I don't want to get them wrong. But you're talking about multiple years of exposure on the back end. Renewals, same thing. I mean, you could be renewing a current tenant, you could be renewing, a household where you've swapped out a roommate or something like that. Everybody who comes into the unit with a lease needs to be told, how it is the property is licensed and registered. And speaking a little bit about legal limitations, perhaps the most devastating consequence of not having a basic business license and a RAD form is that you do not have access to the District of Columbia Landlord and Tenant Court. Full stop. On day one, if you do not have those documents, we attach them to every single lawsuit we file. The court reviews them, and if you file a case without one, the court is going to flag it and ask you on the first day whether you have it. And if you don't, your case 99% of the time will be dismissed. I say 99% of the time because there is a caveat for exigent circumstances which resulted in you not having a basic business license or RAD. That could be things like tenants refusing access and everything. You still don't want to be in that position if you can avoid it, because quite honestly, you're litigating a case that you brought and you are on defense on day one. Conrad, did I cover everything you want me to there, or you have any thoughts?
Yeah, no, that was fantastic. And since you alluded to the Maryland lease, many people would think that just inside the DMV, these leases are interchangeable per jurisdiction, but Maryland has different laws, and we're not going to get into them, but they've enacted a couple new legislative updates, specifically related to like rent control and other things. Virginia is certainly different as well. And so back in about 2018, Maryland and DC recognized the need to split those leases, and DC actually had a revision made last year where it's very clear that the rent control registration or exemption numbers and the license number need to be reflected as is expected in the disclosures and of course, like you said, the marketing, so that everybody knows what they're getting into well before they execute those documents, right?
Right. About transparency these days.
Yeah.
And that's fine. If you're compliant, you want to be transparent, right?
Yeah. And so, that bottom line, like I said here at the bottom, but once you've obtained it, that licensing, you want to maintain it. You want to keep that active license indefinitely, as long as you're going to continue renting out that property. But you also want to make sure it's referenced regularly, because times do change, they do evolve. You're going to be doing renewals. You're going to have to make sure that the tenants are made aware of that going forward. And I will circle back on that a little later, because there is going to be this new rent registry that we're going to expand upon in a few minutes. So you already touched on a lot of this about, like, how staying legal can save you money. You're here and you definitely see a lot of the extreme cases where things escalate. But many of those might be able to be avoided, or at least those pitfalls that you'd alluded to earlier can be avoided, right?
Right. Yeah.
Um, and
Yep.
and so the having the appropriate lease in place, making sure that your property remains licensed is really important. But you've seen some scenarios, and you mentioned it earlier, where you start this court case because the tenant has, I guess we'll say, non-payment is the most likely and most common scenario where owners are going to take suit against their tenants. But since the pandemic, things have shifted, and there's a lot of time potentially wasted to get to the tail end of that tunnel just to find out that you're not going to be able to advance to the eviction.
Right.
So can you tell us a couple of real life scenarios where you've seen that?
Yeah, yeah, absolutely. So we talked about the regulators, right? So DOB, Department of Licensing and Consumer Protection, that's Department of Buildings, and DLCP. DCRA split into those two agencies a few years back. I don't remember exactly when, Conrad. It feels like it was during COVID or right at the tail end of
Yep.
the what I would call the worst part, right? So DLCP usually governs these things, and what they're going to do if you are unlicensed and they figure it out. Sometimes I think they do it by just reviewing records. Other times it's going to be the result of a complaint or a suspicion on the part of the tenant. So not having a BBL can cost you $2,300 to $2,500, right? That's just the fine. The fine doesn't absolve you of the need to get the BBL, so you still have to go do that. And then the RAD registration is another 2,300 to 2,500, right? So that's probably the least scary thing. That's kind of like getting caught by a traffic camera, right? You're going to have to pay the ticket and you can't keep speeding, but that's not the civil liability. That's what I would call an administrative penalty or a civil penalty. The civil liability is the much scarier thing, and we're getting into like the nightmare scenario of the presentation here. Um, in a situation where you have a tenant that has lived in your unit for say 5 years, and you sue them for non-payment of rent, you attach the RAD form, you attach the BBL because you have it at this point, but you never told the tenant that you were exempt from rent control. That tenant has the right to file a tenant petition with the Office of Administrative Hearings, and that will challenge the rent level based upon increases that were taken over and above the rent controlled amount, right? If that happens, your LMT case is stopped cold. There's a case called Drayton out there, and you have a Drayton stay, which basically says we're not going to continue the landlord tenant litigation until the Office of Administrative Hearings weighs in on this. They're the experts when it comes to rent control and all things Rental Housing Act, right? So then you're having your hearing over at the rental account or the Office of Administrative Hearings. You're liable if the tenant proves their case for a rollback in rent back to the rent controlled level, right? So I mentioned that on the last slide, but that's not really the end of the exposure, right? So you're going to refund them the difference between the rent controlled amount and the rent control exemption amount. But by this point, that tenant is on a month-to-month lease. You can't go back and redisclose that you are exempt from rent control. So the tenancy is rent controlled in perpetuity, essentially, right? So the very next month after your OAH hearing, if you get a judgment against you, you're going to pay the tenant, right? Your landlord-tenant case is probably torpedoed because that tenant presumably has the money to pay the rent-controlled amount. So they're just going to do that. Case is redeemed. And the very next month after all of this happens, you can't take a rent increase to the rent control exempt level you want, right? You're limited going forward during the course of that tenancy to the rent controlled amount. Now, I've had people ask, well, during the last 5 years, wouldn't I be able to increase the rent incrementally subject to rent control? So do I roll it back to the 2020 level, or do I roll it back to what it would have been in 2021, 22, and so forth, had I been giving rent control increases? There's an incredibly experienced judge at the Office of Administrative Hearings who's taken this question up. And, while I hate to say it because I represent landlords, I think he's right on this. The answer is no, because you didn't give notices of rent increase to the appropriate level in 21, 22, 23, and so forth, right? So you're going back to the original level, and your next rent increase will be 2% plus CPI the next time you're allowed to do it, and it'll be 2% plus CPI in perpetuity. And Conrad, you've probably seen years where the CPI is a goose egg, right? I mean,
years. Yeah.
You're stuck with the 2% in those years. And as we all know, that doesn't even keep up with inflation these days. So that's all to say, maybe I am trying to scare you into making sure that your documents are in order, but the exposure is massive from I'm going to have to pay out the tenant perspective, but also in the future of your business perspective, because these leases in DC essentially never end. They are life estates in your property. Proactive self-auditing for compliance. So, one thing I'll say, and I'm sure Conrad's got strategies and EJF helps with this, but when you file a landlord-tenant case, everything is in order. You've got your documents, you're fully compliant, you file the case, you're going through an 18 to 24 month on average process to get to a judgment. And let's say you get to that point where you've got your judgment, and then you go to file the writ and you realize that because BBLs expire every 2 years generally, the BBL you had when you filed the case is no longer valid. So you're going to have to refile the BBL. Hopefully you don't have to do an inspection, but I know sometimes you do at the renewal stage, and you've got to file the new BBL with the writ that you get to file after your judgment, right? So it's like, if you're not paying attention to your BBL expiration dates along the way, it's like getting to the end of the game and learning that you lose even though you sort of won, right? You're looking at another couple of months before you can have the U.S. Marshals conduct an eviction. So I live off of Outlook. My calendar, dictates where I am and what I do every day. If I were me, I would just put it on my Outlook every 2 years, or I guess every year and a half, really, to be safe. Check on my BBL, something descriptive, so you know what it is you're reminding yourself of a year and a half from now. But Conrad, do you think that's all right?
Yeah, no, I recommend that too. And if you are alluding to what you need to renew, you will be lost. So make sure it's really clear when you make those notes. But you can also use the Scout system. It's it's a DC based website that you're going to be able to go in and double check when your lease is up for renewal. And so, I'm sorry, your license is up for renewal. So one of the things that we would certainly do if we're working with a new client, just to make sure that they are in compliance and doing an audit beyond the lease, beyond making sure that all those appropriate disclosures were in fact provided to the tenant, making sure that that license is active. And then of course, if it's not, getting you there, right? And so if you have a tenant, and the reason we're doing this around this time of the year is because most leases are generally started in the late spring, early summer. So you're probably in that cycle right now where you have an opportunity to extend or renew that lease with your tenant. So this is a great opportunity to get those things in check and in compliance, right? And so I'm happy to consult with anyone that's trying to make sure that they are covered going forward. So you should be able to just pull those documents up, make sure you look over what you got. We can share out a couple of links to make sure you've given the tenant's bill of rights right? That has to be shared. Lead paint disclosures are a few other ones that we're not even going to expand upon today. But make sure that the license is referenced and the property has in fact been registered as subject to or exempt from rent control. Because if you don't register, you're automatically subject to, right?
Yep.
And so you want to make sure you get that squared away in pretty short order. Now, it's not all doom and gloom. As one, the next screen that we're going to talk about is the mayor's rental act, which we're curious to know if it's going to have an impact. They've recognized that there, especially since 2020, there has been a correction that's not yet been made 5 years after the fact. And so this rebalancing expectations for neighbors and tenants and the Landlord Act, otherwise called the Rental Act, it aims to reform several of these areas of that housing policy so that there is, I wouldn't say an even playground, but at the same time, they do recognize that some of the pitfalls that were put into place with some of the previous legislation, it has impacted tenant safety. It has had an impact on the landlord's capacity. And we both are monitoring this very carefully. In fact, I think we're both on different different committees monitoring and trying to revise this legislation, especially since so many council members are putting in new legislation each and every single month, just trying to stay ahead of this, trying to really tailor it in. And so I've talked to a few council members, and I'm sure that you've been heavily involved as well. So tell me what your impact is, because I know right now there's several months to be able to get in front of a judge. Is this going to have an impact? Is it going to be betterment?
Yeah, it should. So the whole thing is good news, right? And I mean, so Conrad and I met, I think, in 2016, and 2016, Brian and Conrad, I imagine, never would have thought we'd see a bill like this in our careers. But I think it's a recognition that some of these COVID era policies cannot remain permanent. I mean, if anybody reads Biz Now, they just reported yesterday there's been a 79% decrease in new housing production over from last year, which is a scary number, right? For a district, a city where you have an affordable housing problem already. I think a lot of it is going to have to be hashed out still, but there are a number of places here. I referenced an 18 to 24-month process. There are places in this bill where it says things like the court shall set a hearing within 30 days in the event of a public safety case. The court shall set a hearing within 45 days in the event of a non-payment of rent case. Now, whether or not the court's going to have the capacity to do that, to comply with what the statute says, were it to pass tomorrow, that's an open question. But it kind of tells you where the mayor's head was at when this was introduced, and I know the industry certainly appreciates it. In terms of streamlining the court process, one of the big things here, if anybody, hopefully no one here has ever had to sue anyone for non-payment of rent, but if you have, you know that it starts with a 30-day notice of past due rent. This shortens it to 10 days. So it's much more in line with Virginia and Maryland. Same thing with public safety evictions. For criminal conduct, it would no longer require a conviction, which can take years to achieve. If you want to issue a notice to vacate, it only requires an arrest or a charge. So what I think is maybe part of the impetus for this is that they looked at neighboring jurisdictions, and if anybody here owns property in Virginia or Maryland, and I know Conrad is familiar with both jurisdictions, things are quick, right? Especially if you assault a property manager, or you damage the unit or something like that. That case is getting resolved, even with a trial in fairly short order. Not so in the district, and I think this act is aimed at making sure, as one council member said, that we're not the hole in the donut when it comes to rental housing investment. In terms of the technicalities that we talked about, it also addresses that. Hopefully nobody here has had the misfortune of having a typographical error or an out-of-date registered agent or something like that on their RAD form. But right now, the way the law is written, that can be fatal to your case. So you have to go and amend that form and then refile. The Rental Act would give judges back some discretion in determining whether or not minor deficiencies in the lease or the BBL or the RAD are actually fatal to a case. And the way it's written, I think, suggests that unless one side is, improperly prejudiced by some error in a 15-year-old RAD form, the case is going to proceed, which is, another huge development.
All right. And then, of course, with the Tenant Opportunity to Purchase Act, there is expectation for additional reforms because it is slowing development, like you'd alluded to about the cranes on the horizon in new development. But single family, for the majority of this audience, that had been adjusted back in 2018, and so there's opportunities for additional guidance there. But this is for the bigger picture for multi-units that they're looking to make some additional revisions on.
Yep.
I know that we're coming down to the last couple of minutes, and I wanted to make sure that I expand a little bit about the rent registry and still leave time for questions. So we probably will go a little over. But there is the Department of Housing Community Development. When you have navigated through that whole business license inspection, applying for the license, getting your license obtained, and then at the tail end of it, for the last handful of years, you've been submitting a form to register that property subject to or exempt from rent control. At that point, and everybody hears rent control and should, I hope, know what that means, but we're happy to expand upon it, whether or not you are subject to or exempt from. But for the last 40 years, it's all been paper-based. The other aspects of this process, the scheduling your inspection earlier this year, they made that a digital through a website. You're able to get it registered. You're going through the paperwork with the Office of Tax and Revenue and applying for your license all online. This is finally getting this division brought up to today with the rent registry, where you will, instead of being able to submit paper, which they're going to no longer allow, you're going to have to go in and do this re-registration. For those who have been in compliant, you are going to have to re-register. The portal's not open yet. It will be begin June 2nd and run through the end of August, a 90-day window that DC Council has imposed for the re-registration, and everybody is going to need to go through this to make sure that there's that visibility, that transparency. The goal was that the DHCD should be able to monitor and track and be able to know where the potential challenges are and what the forecast of the housing market trends, and providing that data so that everybody can see it. They just never had a sound policy to be able to monitor and do. And so this new expectation, which if you haven't already been made aware of it, I'm glad you're tuning in now. We will share out the link so that you can see a recent overview. I had hoped to be able to share the one that I attended on Tuesday for small housing providers, giving direction on how to do it. I'm happy to share it once it becomes available. But ultimately, for those in compliance, this is going to be an extra step that you need to monitor and make sure that you go in and re-register over the course of the summer, so that you remain in compliance. And then your tenant, the housing providers, the public information is all going to be visible by all. All right. I'm happy to expand upon that, likely as we learn more about it. But over the last couple of weeks, they've been doing a handful of different video webinars similar to this, where they're just walking people through the process and what it looks like. Okay, so be mindful. You're going to have to re-register your rental properties and enter that accommodation info, and then do that annually going forward. So that reminder that Brian mentioned, putting it on your calendar, not only you're going to need to make sure your license is renewed every couple of years, you're going to want to make sure that you're going in and doing this. Now, we have partnerships with companies that are great about making sure that this paperwork is done, rent control, subject to rent control or not. But you're going to need to make sure that you have a capacity and the process in place to do it yourself. We've already enacted some changes that are going to help our clients with this going forward. So it's just one less headache that they have to deal with. So big recap, since I do want to leave a few more minutes for the questions, but we want to make sure that everybody is and remains in compliant. You got to cross your T's, dot your I's, especially in this day and age. You need to have processes in place for tracking capacities. and not ultimately want to monitor the mayor's rental act, but also start getting in compliance with this rent registry, which you cannot do yet. But effective June 1st, it will start opening up for availability. We're happy to share these resources. A lot of it is available on our website under our owner portal under section. And we do have some additional legislation that I want to make sure people keep on the radar. One of which is going to be the Pets in Housing Amendment Act of 2024, which is also called like the Roscoe Law. But that's going to be related to the amount that you can charge for pet rent, what pets will be allowed to be in the property, and which ones you are not going to be able to not allow within the property. There is also conversations about the future eviction expectations, because once you've gone down this road with your tenant that we've expanded upon and gotten all the way down towards the tail end with the actual eviction, there are concerns about the way that the evictions are held by the U.S. Marshals, the temperatures related to it. And now there's one council member that wants to say that if it's over 95 degrees, you can't do it either. So it really limits the window of opportunity to evict your tenants if you are able to navigate through that whole process. So with that said, I'll open it up to any questions that our guests have.
Yeah, and Conrad, I've got it in front of me here. Oh, sorry to interrupt. You want me to just take them?
Yeah,
Yeah, go ahead.
go for it.
Great. Yeah, so one of the first ones was when you say rent control, is that the allowable percentage increase annually? Yeah, that's what I was talking about, rolling back to the rent control level. So you'd start at the beginning of the tenancy or as far back as the statute of limitations would go, and then you would start calculating the rollback based upon everything over that level that was improperly taken. The rent control amount is typically 2% plus CPI, unless you've got a registered elderly or disabled tenant. I see one here, Conrad. One of my owners has repeatedly tried to file their ad, and it's called their ad office, sent it in via certified mail, and nothing happened. So most often, I think these are filed online now. It used to be, Conrad's probably been down there too. You'd go down to, they used to be at 1800 Martin Luther King Avenue. They're somewhere else now. I forget the exact address, but you don't have to go down there anymore. You can submit these things online. I think you can email them in, and then they will give you a date and file stamped copy, and that takes maybe a week or so. Is that about right?
I'd say when it comes to the district, 10 days to 2 weeks is probably going to be commonplace. Get it sooner than that, you can be a happy camper, but I would leave it towards the tail end for that expectation. And yes, they are taking them via email. I think it was an editable PDF that I do have a link to, which I should be able to forward over. So if you reach out to me direct, I do have that email and form. So that way you at least have some form of acknowledgement, as opposed to just mailing and getting nothing. It's a lot more productive than physically going down there.
Yeah. I see. I like this next question, Conrad. So if we have to re-register digitally this summer, is it okay to ignore those that aren't registered now, so we can avoid duplicating efforts, time, and money? Somebody's playing with matches.
I'm not the attorney here, but I can see that there is a likelihood that there will be owners that are going to have to do something twice. So I can see the logic.
So look, my thing on this is it depends on your risk tolerance, right? In the next, you said it opens in June, I think. In the next 30 days, is somebody going to sue you for not having it? Is DLCP going to come out and levy a $2,500, $5,000 worth of fines? I don't know. I can't say. Technically, they could. The tenants could file a tenant petition. DLCP could issue a fine. I think it's really a case-by-case basis. You're going to have to decide whether the time and pain in the neck associated with getting a BBL and RAD is worth it just to have to do it over again. If we're talking about the BBL, though, I would say go ahead and do it, right? Do that now, tomorrow, or when you get off this webinar, because you're still a month away at least from having that BBL in your hand, right? The city's going to have to do the inspection and the whole process. If you're talking about the RAD form, it's not a huge pain. I mean, you use the information from your C of O and your BBL to fill that out. You email it in, as Conrad said, you'll probably get it back in 10 days. It would be annoying if it takes, 2 weeks and you have a RAD for 2 weeks that you just re-register 2 weeks later. It's a as I said, it's with the district. Anything like this is you're playing with matches, and maybe it works out.
If they'll allow you to do it, because
Right.
the new rent registry is going to make you search for the valid business license before you may be able to enter that information. So
Yeah.
if you haven't done this, it's water under the bridge. Start now. You do have to get your inspection. That tends to take 10 days to 2 weeks just to get scheduled. There are opportunities to go into get a feel for whether or not you're going to pass, because DC does share that inspection report. And I'd alluded to it in a previous webinar about they basically giving you the answers to the exam and the inspections of the test, right? And so go through it, make sure you know what it is. If you have a tenant in place, I would not rely upon them to provide access to the inspector. I would suggest you go yourself. We also discussed the fact that virtual inspections, when possible, have a higher success rate than in person. And so you do have that opportunity to get the ball rolling. And seeing as we're at the tail end of April, you got May and June. So this is probably the timeline where you're going to need to do it. And you probably will hit it in stride if you get started now. All right. And of course, with that RAD, they are going to be monitoring it. You do have to mention it on the documents. Another question that I saw is the price points for getting your help to renew. Renewing licenses, if you were to just do it straight up with DC, I think the fee is what, $198 and change or something like that, under $200 for a 2-year license. To employ somebody else to do it, there's a couple companies that we have worked well with that can navigate it for anywhere between $500 and $700, inclusive of that $200 fee. So an administrative fee for that. And if you are not local, be mindful of that, because you do need to have a registered resident agent in order to make sure that they're getting those notices as things progress as well.
That's a good point, Conrad. And something I see a lot is people will fill out RAD forms and they just skip that piece because they don't have one or they don't know what it means. That's enough to get your case thrown out of court. So you're filling out every part of the form. And if you have a question, Conrad's got contacts for you that can help with that. Just don't skip any fields. I don't know why it happens so often.
Yeah. And there are some fields that aren't applicable to everybody.
Sure.
But
the identification fields on the first page is what I'm talking about.
Yep. Does EJF provide, unfortunately, the question was, does EJF provide service to landlords to secure the BBL and RAD forms? Since the beginning of the pandemic, it had become more challenging in many cases, but I do have a couple partners that I can link you with in order to be able to pursue that if you don't have the capacity on your own. It is navigable if you break it into bite-sized pieces, but I do recognize that that is a concern for many to make sure they're doing it right. The legislation on the new re-registration, I will post out, and maybe if we didn't put it into the chats, we'll be able to share it out as a summary to the meeting for those who are here today and registered. What if your tenant hasn't paid?
Is that on the DHCD website, Conrad? The walkthrough of how to get it done and everything, the re-registration?
It is, yeah. And they're doing a few demos and they are sharing them out to YouTube. And so I have those links and we'll make sure that they're included in this summary.
Got it. I see another one here. If you have more than one rental apartment, does each apartment need its own BBL, et cetera? So if you it's by address, right? By the tax ID lot, right? So if you have a multi-unit building, if you have a 4-unit building, you're going to have one RAD and one BBL that covers the building. If you've got 2 condos within a condo building, you're going to have 2 BBLs and 2 RADs, right? Because those are 2 distinct legal property entities. So if you've got one here and one across town, obviously 2 BBLs, 2 RADs. So that's generally how that works. Let's see. What if the tenant hasn't paid for a year? You're going to want to talk to somebody after this webinar, that's for sure. And that's also not uncommon. In terms of the ability to get to court without a RAD, RAD or BBL, it does not matter, unfortunately.
And staying on top of your tenant is really critical. As much as I would love for my children to brush their teeth every night, they don't, and I constantly have to ask. And so it's the same approach sometimes to reminding tenants that rent's due, and also making sure that you intervene sooner than later so that it doesn't get to be worse, right? I, without the illusion, like, as far as the kids into brushing their teeth, obviously that can equate to a big dentist bill. In this situation, that's thousands of dollars being lost. But you know, we generally want to make sure that we're following up regularly, and our team's reaching out to Brian and his team around the 15th of the month, trying to figure out where we're going to proceed from there. Because falling 1 month behind is manageable, and you should be able to catch up. We did not talk about ERAP and a lot of assistance programs, but that's also something that the Mayor's Rental Act is working to improve upon. But ultimately, in the end of the day, staying on top of your tenants, making sure that it is that they're staying up to date on their expectations and obligations, but then also taking action when they're not. And so 2 months is 4 times as hard to catch up on. Once you get past 3, 4, 5 months, I mean, it's almost unmanageable. So take action right away. Don't let it get to that far, but we will happily talk about options there. All right. So fantastic. Well, thank you so much for joining me, Brian. As always, it is great to chat. And as much as it may sound like doom and gloom, all of this stuff is preventable to a degree. And most of it starts with the due diligence on the front end. But we are happy to navigate the process and be able to assist and answer questions. We do take the weight off of a lot of owners' shoulders to make sure that this is done right from the beginning. And at the same time, obviously, life happens and we cannot make any guarantees or promises, but we certainly want to mitigate and reduce that potential liability. But we have great attorneys that are able to assist us when that day does come so that we can give you guidance on how to handle those next steps. So I thank you all for joining. I appreciate sticking around, and sorry we went a little over time, but there's a lot to cover, and I look forward to doing the next session in the near future, because if you do all this work and you get into compliance, making sure that you're inspecting it, that the property remains compliant, and you're taking care of maintenance timely, makes for a happy tenant, and will also continue to reduce the stress that could evolve associated with being a landlord in the district. So thank you all. I appreciate your time.
Thanks so much, Conrad.
Thank